Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. It's my great pleasure today to be sitting with Justices Sachs and Walsh, and my name is Gabrielle Wolohojian. We're hearing one matter on our docket this afternoon. It is in the case of 2022 P0155, Janet Avila versus Dr. Bisola Ojikutu and others. And with that, we are ready, and the issue before us is a motion to dismiss, and we will hear first from the movant.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. My name is Batul Raza, and I represent the Boston Public Health Commission and Dr. Bisola Ojikutu. I will also be arguing on behalf of City of Boston and the mayor, and collectively I will refer to all four parties as public health authorities. One housekeeping, Your Honor, you mentioned that this was a hearing on appeal number 155. My understanding is also a hearing on appeal number 118, sorry.
That is correct. I should have called that as well. It's 2022 P0118.
Okay, thank you, Your Honor. So, Your Honor, as the cases have been mentioned, appeal number 155 and appeal number 188 are both appeals that were initiated by the two parties as a result of an underlying eviction moratorium that was issued by the Boston Public Health Commission through its executive director on August 31st, 2021.
I'm sorry to interrupt, Ms. Raza. We don't have the clock going yet.
I just realized that too.
Great.
Okay. So it was the eviction moratorium that was issued by the Boston Public Health Commission through its executive director. That eviction moratorium was rescinded on February 25th, 2022. A second eviction moratorium was issued, which was significantly different from the first one, and that expired on March 31st, 2022. So currently in the city of Boston, there is no eviction moratorium. In fact, there's no mask mandate, there's no vaccine passport, there actually isn't even a public health emergency, which also expired on March 31st, 2022. Additionally, the single justice order, which is subject of appeal number 155, expired by its own terms on February 28th, 2022. So all these orders are more than 2 months expired. So currently there's no life controversy in these matters. And in accordance with case law cited by us in our briefs, at this time, there is no effective relief that this court can grant either parties, public health authorities or the plaintiff landlords. And so in accordance with, Branch versus Employment Relations Board's City of Lynn versus Morrell more recently for the SJC, both these appeals are moot. And therefore-
I have a question about, you mentioned that there's no current public health emergency. And just remind me, did the city declare its own public health emergency independently of the state?
Yes, Your Honor, it was through the Boston Public Health Commission's order.
Okay, so what in your view is the connection between that fact, the fact that the public health emergency has expired, and any of the other facts to which you've pointed, and also to the question of whether this is a type of question that's capable of repetition but evading review?
Thank you, Your Honor. So in regards to what relevance the expiring of our public health emergency has is several reasons. One is that in the city, there is no declaration that purports that there is an ongoing health pandemic that is at such a level that would allow boards of health or entities like the commission or the Boston Public Health Commission ability to do pass additional emergency orders without on their own terms.
So the agency's authority is dependent upon the existence of the declaration of a public health emergency. Is that what you're arguing?
Well, yes and no. So public health, so my reason of bringing up the fact that the public health emergency has also expired is also to show that the state of the city is in right now. There is no declaration of a public health emergency, which means there is no steps that the city or the entity would be taking to combat a disease, to prevent the spread of that disease, which is
I know, but my question was a little bit different. It had to do with authority.
Your Honor, any orders that the commission would issue would be in connection with or with consideration with the Board of Health, which is our governing body, and the mayor.
So it wouldn't have authority to issue an eviction moratorium unless a public health emergency had been declared?
Your Honor, it would have the authority to recommend it to our Board of Health and for their consideration, which is the governing body of the city of Boston, or of the Boston Public Health Commission, sorry. So at this time, without that declaration, it is definitely, there are more steps involved than just declaring emergency orders at this time by the commission through its executive director. Would Your Honor want me to now go on to the second question that you had asked?
You can use your argument time however you wish.
Okay, so as I had said, that this case is moot because there's no effective relief. There are exceptions, and Your Honor has already pointed us in the direction of that. And one of them is the court can use its discretion to decide moot cases. It is a 4-pronged test, and 2 of the issues that Your Honor has brought up are likelihood of repetition and evading review. And it is the public health authority's position that there's absolutely no indication that, nor have the plaintiff landlords been able to point to any indication that a repetition or an order such as the eviction moratorium is likely to come up in the near future. And this is, kind of strengthened by the fact that the first order that was issued was rescinded, and the second one was already much different than the first one. And as I had alluded to or mentioned in the past, other emergency orders that were issued by the Boston Public Health Commission have all but expired, including the public health emergency. So the only facts that are, available before this court at this time are that, there is no substantial likelihood of a similar order to come up in the future. Anything that there is a speculation or it is speculation, which is what the SJC, which is in my Rule 16 letter, we had referred this court to City of Lynn versus Morrell, where the Supreme Judicial Court found that in order to decide a moot case, the court should be presented with concrete examples of repetition and not mere speculation. And it is the Public Health Authority's position that any allegation of any future similar or substantially similar order, which is what the standard is mere speculation. There is no concrete evidence of that fact. In fact, given the state the city is in, it is quite to the contrary. And I would also, so that's one. And the second thing is that at this point,
for purposes of the argument that I understand the plaintiffs to be raising, which is really an attack on the authority to promulgate a moratorium, not the details of the moratorium itself, the authority to promulgate a moratorium. Why is that not capable of repetition?
Your Honor, because the authority that the commission or the Boston Public Health Commission has is fact dependent. It's based on Chapter 111. It's several statutes, but one of the section is that the boards of health shall issue reasonable regulations to prevent the spread of disease. And reasonableness is a fact-specific analysis. And at this point in time in the city, there is no moratorium. It hasn't existed for more than 2 months. And so to now rule on our authority when the facts don't exist is not an appropriate use or appropriate way to use the resources at this time. So based on that, there is no concrete evidence that this is likely to repeat itself in the near future in the exact same factual circumstances or substantially similar ones.
I have 2 questions. The first is shorter, and I'm going to ask the plaintiffs as well, but it is this. Do you understand the plaintiffs to be making a constitutional argument in their appeal from the single justice order, or would the plaintiffs be making a constitutional argument in defending the appeal from the housing court order?
Your Honor, that's a great question, and I don't understand the plaintiff landlords to be making a constitutional claim. That was not alleged in their complaint. It was a declaratory relief that they were seeking to declare that the commission didn't have the authority to issue the order. And
it's basically dependent on interpreting the statute and the regs, not the Home Rule Amendment or the 14th Amendment or whatever we might have.
That is correct.
Okay. The second is this. The plaintiffs have argued that the public health authorities repealed the first moratorium and issued a second time-limited moratorium specifically for the purpose of mooting the appeal and getting the housing court judgment vacated. If it were true that mooting the appeal in order to get the judgment vacated were a reason not to vacate it, then is the burden on you to show that that was not the purpose, or is the burden on the plaintiffs to show that that was the purpose of ending the moratorium?
Sure. I think Your Honor brought up a point that I had wished to argue is the plaintiff landlords seem to suggest that this is a defendant-initiated mootness, that we somehow amended our eviction moratorium in order to avoid litigating the appeals. And in Boston Bid Bar Labs versus Governor Baker, the First Circuit, which is a case I have not cited, but I would like to bring to the court's attention, and that case has been cited in City of Lynn versus Morel. The court does a pretty lengthy analysis of that, of the defendant-initiated mootness, and in that, the court finds that to a defendant that does a defendant-initiated mootness is a specific kind of a scheming defendant. In this case, there is the reason that the Boston Public Health Commission rescinded its moratorium was not to avoid litigation. It was where we were in the pandemic at that time, because this was not the only order that was rescinded. We rescinded the mask mandate. We rescinded.
Judge Sachs's question was, who has the burden to show what the purpose was?
Oh, sorry. The burden would be on us to show that it's not that. And so I would argue that, the commission, the way the city was doing at that time in the pandemic, or where it was in the pandemic, and the strides we had made was the reason that we rescinded the eviction moratorium along with our public health emergency declaration, rather than any attempt to avoid litigating this appeal.
And is there any evidence in the record on that? Is that a fact-specific question for which we would need evidence?
Your Honor, in Boston Bid Bar Labs, the court pointed to the strides that had been made in vaccines and testing. I would say we are even further than that here. We have home tests available. There's, antiviral medication. Those are all facts that the court and the SJC and City of Morel also made references to CDC guidelines and so on and so forth. So I would say that given that this information is readily available, the court could look to it or take the judicial notice of it, given that we publish this data on our website on a daily basis.
And that evidence establishes, in your view, that the purpose of mooting or ending the moratorium was not to moot the appeal and get the housing court judgment vacated, but because of developments in the pandemic.
That's correct. It is, the city had made strides, or the country as a whole had made strides on where we were at combating the pandemic than we were before.
Do you agree that if we were to decide the case is moot and does not fit into the capable of repetition, yet evading review in matters of public importance, so forth, exception, that if we decided that either of the judgments appealed, either the judgment or the order should be vacated, that we should vacate both?
Your Honor, our position is that the order of the housing court should be vacated because that truly is the underlying controversy in both the appeals, is that the housing court declared our judgment, our moratorium order as invalid and issued a judgment on that. So it would be our position that given that the underlying order is the housing court order, that order be vacated.
Is there any reason to treat them differently in principle? So that if we were to decide hypothetically to vacate the housing court order, is there any reason not to vacate the single justice order as well?
Well, Your Honor, the single justice's decision was a use of his discretionary powers. So in his discretion, he issued a judgment on a motion to stay. And so to, vacating that order, I don't think is, would make is not appropriate given that the underlying order is the housing court order.
Do you have a case to support that argument?
So the argument that
that you wouldn't vacate the single justice order?
So Your Honor,
if we were to dismiss the appeal of the single justice order, do you have a case to suggest that the remedy is not to vacate the single justice order?
Your Honor, off the top of my head, I don't have, but I believe that we have cited to a case regarding the single justice discretionary powers.
That seems to me something else, a different question.
I understand that. So I don't have a case to cite at this time, Your Honor. And in closing, I would just like to address the evading review, which I don't think we spent a lot of time on, is really quickly, there's in City of Lynn versus Morrell, the court noted that there's no reason to believe that our appellate system can't move quick enough when it so requires, and it cited to DeRosiers, which I think is a good example of that. So,
Thank you. I think we'll have to leave it there.
Okay, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Attorney Maturin.
Thank you, Your Honor. May it please the court, my name is Mitchell Maturin, and with attorney Jordana Greenman, we represent the landlord plaintiffs in this case as appellees in case number 2022 P0118 and as appellants in 2022 P0155. My argument today will follow four parts. First, the dispute is still live and has not been rendered moot by the BPHC's revocation of the moratorium. Second, under the voluntary cessation doctrine, BPHC's decision to change its behavior does not render the case moot. Third, even if one or both of the appeals are moot, the court has discretion to decide the appeals anyway for two reasons. First, because they're questions of extraordinary public interest and there is ongoing uncertainty. And second, because the issues are capable of repetition yet will evade review. And finally, if the court determines that the BPHC has successfully mooted its own appeal from the housing court's decision, then the court should dismiss that appeal, but leave the housing court's decision in place. And if the court determines that the BPHC has successfully mooted the landlord plaintiff's appeal from the single justice decision, then the court should vacate the single justice's decision. First, the dispute is still live. Landlords across the state have suffered from the pandemic for longer in a more targeted way than any other group. For nearly a year, the entire summary process system was shut down, and landlords could not take possession of their property for any reason. After that, they continued to be unable to exercise their legal rights where failure to pay rent was due to.
Could they not pursue summary process actions for cause?
I believe only in the case of an imminent threat to the health or safety of other tenants. That was certainly the case under the Boston moratorium, Your Honor. That there is a ban on anything for cause or not for non-payment or not non-payment, unless the court has specifically found that there is a imminent threat to health or safety. So it's effectively a ban on everything. So what we have here, Your Honor, is that once the Supreme Court struck down the CDC moratorium, which is only focused on economics, suddenly the BPHC came in and declared a complete moratorium on evictions for any reason except, as I just noted. And landlords have an ongoing interest in this dispute. They continue to own rental properties and they continue to rent those properties out. And this is an unprecedented risk to their ability to do so. That has a direct impact on their decisions to continue renting at all.
Of course, it's over now, right?
Well,
like the orders have ended.
It's over for the moment, Your Honor. But as you might have noticed when you specifically asked the Boston Defendants Council whether or not this could happen again, absent an emergency order from the city of Boston, there was a lot of hemming and hawing. Well, it could happen and that sort of thing. So there is no question that it could happen, Your Honor. And if you go on to the single justice's opinion, what the single justice did is said that cities and towns can, without violating state law, impose restrictions on the landlord-tenant relationship and on evictions for up to 6 months at a time. And that they can do that under the SJC's decision in Grace. Now, Grace was not a public health case at all. So if the SJC is right that Grace holds that cities and towns can do this for 6 months at a time, then it's not just limited to whether or not there's a public health emergency or whether or not there's a pandemic. They can do it at any time, and this is why the SJC's decision, the single justice decision is so damaging, because it sets up this brand new risk that landlords have not had to deal with. Now, there are lots of inherent risks to being a landlord, and Massachusetts has some very, very strong tenant protections, and all of those have been established for years. But suddenly, the BPHC came along, and without any state declaration of emergency, and importantly, without any state authority like there was in Grace, imposed their own restriction, a ban on evictions within the city of Boston. And the issue is live now, despite the city's attempt to backtrack from it, because Somerville has an—
Before you go back to the, if you don't mind, before you go on to that, how do you distinguish the City of Lynn decision?
The City of Lynn decision is distinguishable for several reasons. First of all, the City of Lynn did not deal with the voluntary cessation doctrine. And if you look at—
Okay, if we set aside your argument about voluntary cessation and just look at the mootness analysis itself.
The City of Lynn case involved a preliminary injunction that the City of Lynn had gotten against a business for failing to follow the statewide mask mandate. The mask mandate was implemented at the beginning of the pandemic back in early 2020, and it had been revoked in the meantime. The preliminary injunction had actually never gone into effect because the court immediately stayed and certified questions for review. And then once the mask mandate had been revoked, there was simply nothing there. The case also only involved that particular plaintiff, whereas here we have landlords across the state and tenants across the state and cities across the state who are unclear on exactly what can be done and what the risks are. The issue also in City of Lynn, the revocation of the mask mandate there had nothing to do with the litigation itself. It had to do with the state's determination that there was no longer a need for a mandate. Here we have—
that takes us to Justice Sachs's questions, I think. And I take it you won't disagree with Attorney Raza's view that the city defendants had the burden to show the purpose of the rescission.
I do not disagree with that.
Okay, and so you heard what she recited as the evidence to support the conclusion that as to the city's purpose. And what do you say to that?
Well, I don't think there is any evidence that's cited, Your Honor. But first of all,
But you don't, what evidence do you have that the purpose was to, and I assume it has to be solely, right? Solely to defeat the appeals.
well, I don't know that it has to be solely, Your Honor, but the point is this.
It would be very hard to create a rule unless it were solely, if they had a perfectly legitimate reason for rescinding the order. And ancillarily, they also, thought there might be some litigation benefit. I think that would be a difficult case for you. So
Well,
what evidence is there of their purpose?
Well, let me just go back to when they implemented the moratorium, Your Honor. They implemented the moratorium in the middle, not because of any change in the pandemic, but because in the middle of a political campaign. Okay, and the statewide ban on evictions had long since expired. There was already restrictions on evictions for economic reasons under Chapter 257 of the Acts of 2021. So there was nothing that changed. All the things that they are pointing to now, vaccines, treatments, infection numbers, those were all in existence at the time that they implemented the moratorium to begin with. So there was no triggering factor back then that we can now say is gone, and that there is no longer, because there are no new treatments or no new vaccines. And in fact, the Delta variant, which was on the rise back in August of 2021, has now been replaced by the Omicron variant, which is now on the rise. And so there has been no actual change in the facts on the ground that would justify the revocation of the moratorium now that didn't already exist at the time that they imposed it. So if we look at then at the BPHC's behavior after getting the single justice's decision, the single justice held that under the Grace versus Town of Brookline case, a city or town can impose restrictions on evictions for up to 6 months at a time without violating state law. And then he said he was only going to stay the housing court decision for 2 weeks because that would correspond with the end of the 6 months. And he said that, but the city could impose a new moratorium after that. And that's exactly what the city did. They revoked their original moratorium and they issued a brand new moratorium, which, notwithstanding my sister's statement that it was significantly different from the first moratorium, it was not different at all. They had changed a couple of words.
Well, you've said in your opposition that it was different in that it was time limited.
It was time limited. That's correct.
That's pretty significant, at least according to the analysis of the single justice with the significance of the 6 months. And I believe you acknowledge that there was another difference as well, that it was basically, well, I don't want to pause over that issue, but I guess I have a question about the incentives that we would be creating if we determined that the housing court judgment should not be vacated. The public health authorities argue that this was an important public health measure, and presumably they would like their authority to impose such measures in the future confirmed if they had the ability to do so. On the other hand, they've got the consideration that this measure, in their view, is no longer warranted. And it's been alleged by your clients to be very burdensome. So the public health authorities, being responsible government officials, should be balancing what's our interest in getting a decision on the merits versus lifting this measure that may no longer be required by public health and is perceived as significantly burdensome. Do we want to give them an incentive to keep that order in place, notwithstanding that the public health rationale has gone away, in order to avoid getting the decision, in order to get a decision on the merits of the appeal and get the housing court judgment overturned?
Well, Your Honor, the defendants appealed this case. They appealed it presumably because originally they wanted to, at least theoretically, get an appellate review of that case. But when given the opportunity to argue that case, they immediately sought an extension in order to avoid briefing the issue. Then went ahead and revoked the first moratorium and implemented the second moratorium, and then sought to dismiss so that they could avoid it. And I would suggest, Your Honor, that the incentive here has to be to provide clear guidance to cities and towns as to what they can and can't do, and clear guidance as to whether the single justice's reading of grace had any basis in the law. But by saying that we're going to vacate, as you may be suggesting, Your Honor, both the single justice decision and the housing court decision, what you're doing is you're giving the Boston defendants the incentive to do this again, and then to revoke it before we can get appellate review about it. And this is, you know, in the
So
section.
you think it would be preferable, just I want to make sure I understand of you. You think it would be preferable for them to leave the order in place, the moratorium order, even though they don't believe it's necessary as a public health matter, simply to allow the appeal to proceed and for them to, in their view, prevail and get the judgment overturned?
Your Honor, it is in everybody's interest to have a clear decision on this.
And does that outweigh the interest in lifting a public health measure that may no longer be necessary, that's burdensome to your clients?
Well, I disagree respectfully, Your Honor, that that's why they raised it. And if you look at the Rule 16L letter that we submitted and our brief itself, it makes clear that if the losing party ends up doing something to moot the appeal, to moot their own appeal, then the remedy is not to vacate that lower court.
I saw you cited the aquaculture case, or aquacultural research, but is there any ironclad rule that says where a party has taken steps to moot their own appeal, they can never get vacated? Aquaculture seems to say it depends on the particular circumstances. And if
I'm sorry, Your Honor. I was going to say that takes me back to the voluntary cessation doctrine. In Boston Bit Labs, which is cited in City of Lynn, the court observed that where a defendant voluntarily ceases a challenged practice, there is an evidentiary presumption that the controversy continues to exist based on skepticism that the cessation of the violation means cessation of live controversy. And they quote Friends of the Earth versus Laidlaw, 528 U.S. 167. And they say that for a voluntary cessation to moot a suit, it must be absolutely clear that the conduct could not reasonably be expected to recur. And the burden of showing that it does not apply lies with the party claiming mootness, which is Boston. So yes, Your Honor, I would suggest that there is a rule that where a party ceases their own activity and as a result moots that case, moots the appeal, that there should not be a vacatur of the lower court, and that the defendant should have the obligation to show that to meet the high burden of showing that the conduct could not reasonably.
We're going to have to leave it there. Let me see if there are any further questions.
I did have one further question, I'm sorry, which I had promised to ask you, Mr. Matoran, but didn't, is are you making a constitutional argument either as to the, well, let me just leave it at that. I noticed that New England Legal Foundation in its amicus papers does make a constitutional argument.
Your Honor, we made state constitutional claims in the complaint and in the preliminary injunction motion. Count one of the complaint had to do with the BPHC's statutory authority to do it. Count two, and I may be reversing them, count two had to do with Section 6 of Article 89 of the Home Rule Amendment, and claim 3 had to do with Section 7 of Article 89. The Housing Court did not decide the constitutional issues. The Housing Court decided only the statutory authority issue, although she did allude to the home rule issue.
And I suppose that if this were briefed on the merits, you would brief not only that the Housing Court was correct, but that even if the Housing Court was incorrect on the statutory issue, it'd still prevail on constitutional grounds.
On the Housing Court appeal, yes, Your Honor. On the single justice appeal, it has to do with a misreading of grace that is setting up real problems for landlords, cities, and for tenants statewide going forward.
Thank you.
Okay, any further questions? All right, thank you both. We'll take the matter under advisement. Thank you both for your able arguments. And we're going to stand in recess.
Thank you, Your Honor.
Thank you, Your Honors.